Okay, okay, there's a mic floating around.
Hi, I'm Zheng Xi from the Online Citizen. I was part of the bloggers group that put out the proposal. First things first, I think we need to de-link the idea that the bloggers group, which is calling for complete repeal in 33 and 35, are actually calling for free for all. I think we made clear in our proposal in April that that's not what we want, especially in relation to incitement to racial or religious violence, which is covered under Section 298. So in that context, perhaps it's not very fair to raise the example of hate speech in the EU. In specific relation to 33 and 35, this is in relation to political content regulation online. And I think in the area of protection of minors in sexual positions online, I think we're very clear. We're not calling for a free-for-all. We understand that the laws of the land in relation to defamation as well as child pornography should and still apply. So on the question of 33 first, our concern is, well, politics is emotional. And I think we need greater clarity on what exactly the danger, the damage we're trying to prevent against actually is. We need a clearer picture of that in the first place. Next, in light of that danger, is a symbolic or a tokenistic blackout period going to actually make this problem worse? If what you're trying to prevent is polemic, it's going to get out anyway, and it will probably be aggravated by this sort of symbolic legislation. In fact, we saw in the case of Zahari 17 Years and Singapore Rebel by Martin C., it actually got a larger viewership because of the regulations. And the next question is, beyond Section 33, Section 35, we've been asking, I think, for a while, why Section 35 wasn't dealt with. Our concern is if 33 goes, 35, which is actually a broader test, which Zahari 17 Years was prescribed under, could still be applied to political films. All we have is an administrative or a political assurance that we are going to loosen up in terms of political regulation, but allowing the minister to prohibit any film that is contrary to the public interest is a far broader scope than actually Section 33. So,
Okay.
Thank you.
You want to take one by one, or you want a couple of? Okay, right.
Could I?
Yeah.
Because you cover a lot of ground. So, first, what is content which you think could be objectionable, leaving aside hate speech, right? I think what is of concern, is material online, whether it's a video clip or 5 minutes or 10 minutes, that could portray in a political context, that could portray the other party, whether you are a government entity or a non-government entity, that could portray unfairly your opponent, and in the process lead to misunderstanding and an influence on the vote, particularly if it happens a few days. And the time that you have to really rebut is really not there. So that's one concern. That kind of a content, an attack based on falsehood on your opponent, that could have a major impact on the vote, especially if you have a very close race. And this basically is what the Boston group has been pointing out. If you have a scurrilous, that's the word that was used, if you have a scurrilous, deceitful, anonymous clip posted on YouTube, that could affect the vote. And in fact, if you like, there is a very interesting article that was published on June the 30th this year in the International Herald Tribune about how videos are reshaping the presidential race. they gave quite a number of examples of how political content has affected support for or against one of the candidates. So that is what we had in mind when we were discussing this issue in chapter 2. Now, as far as Section 35 is concerned, my understanding of Section 35 is that it empowers, it gives reserved powers to the minister to prohibit a film if he believes or she believes to be against the public interest. What has been the experience so far? I think since the law was enacted, I think only one film fell foul of it. That is the 17 years that we're referring to. Personally, I am not in support of banning that film, personally. No? But as you pointed out correctly, once in YouTube, it attracted a much larger audience. I think that the main arguments in favor of Section 35 is to empower the government to act against films that could potentially have adverse effects on society. And I have in mind a film that was recently made by a Dutch MP. He made a film called Fitna. I don't know whether that's the name of the film, but this is about Islam in Europe. That film was banned in Europe. Was banned in the Netherlands, although you can watch it on YouTube. My question here is, would you, in this instance, say that the government should not have any powers to ban such films? Would you say, yeah, because my understanding of Section 35 is that it does endow the government with powers to act against films like that. Yeah, go ahead.
Doesn't that fall under Section 298? And in light of the recognition that perhaps Section 35 is a bit broad, is there a way to work in an exception to political films explicitly into substantive law under Section 35?
I think a refinement of that section is something that we can consider. To address the common problem that we agreed on, right? If you can isolate, if you can tweak the law to make sure that it only prohibits, for example, the type of film that I cited. That could be something that we should consider. Yeah.
If I can just add, maybe giving a lawyer's answer to your second question. I suppose if Section 33 is repealed or significantly reduced in scope, then that must mean that the legislature has taken a policy decision that political films are not, in principle, against the law. And having done this, I think it would be very difficult to use Section 35 to prohibit political films when Parliament has clearly repealed the provision that prohibits political films. So I think Section 35 will therefore then have to be used in a different way. You've got to show that there is something that is detrimental to society beyond the fact that it's simply a political film. So I mean, that's, in a sense, a lawyer's answer of how I think Section 35 would be interpreted if it was left on the statute books after 33 was repealed.
Okay. Yeah. Just on that.
Okay. I think the concern would be in the public view clarity, because this is clear, I think, to a lot of us in this room. But the signal sent would still be, the broad discretion still exists, and that any allowance is an administrative or political decision. It's not worked in substantive law.
Yeah. Okay. So you're afraid that you'll be snuck in, that prohibitions will be snuck in through 35. Okay.